You secretly recorded on video your doctor admitting that he screwed up and caused your injuries during an office visit. And now you've got this information on your iPhone. And now you keep it secret because when your case comes up for trial, after you've sued your doctor, and now you're hoping to spring it on the doctor at the time of trial. Can you do that? Can you pull out your iPhone and show to the jury exactly what this doctor said and get him to admit again, or to show the jury what he admitted? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is, in all likelihood, if you have not shared this video with the defense, there is a very good likelihood that you will not be allowed to use this video to show to the jury exactly what the doctor said and what he did. Why is that? It's because there's no longer trial by ambush. That went out the window 20, 30, 40 years ago here in New York. You can't ambush your opponent. If you have something devastating in the form of a video where the doctor has admitted screwing up, yes, I'm sorry, it shouldn't have happened, I did it, I know it caused you horrible injuries, but, and now he goes on. Now you've got that admission. That's a fantastic piece of information. But if you try and use that to ambush the doctor at the time of trial, guess what will happen? The defense attorney will jump up immediately. He's going to start screaming, saying, "Judge, Mr. Oginski never provided that information to us before. This is the first time I hear of this." So he will never have had an opportunity to know about this. He'll never have had an opportunity to prepare a defense against it, or to attack it, or to attack its credibility or authenticity. And because of that, now he's going to be furious. And now there's going to be a whole legal argument. The judge will likely send the jury out of the courtroom. And now he's going to ask me, "Mr. Oginski, did you send a copy of this to the defense attorney?" "No, I didn't, Judge." "Well, why not?" "Oh, I just got this yesterday." "Really? Why didn't you send it to him or show it to him this morning?" In a medical malpractice lawsuit in New York, we are required to turn over whatever documents, medical records, evidence we have to use against the doctor. We have to give it to the defense. So now they have an opportunity to see it, to evaluate it, to decide what to do with it, if anything. And now they have to deal with it. But if they don't know about it, now we simply spring it on them, and we don't have a good excuse for why we didn't turn it over earlier. Guess what? The judge is going to preclude us, to prevent us from using that at trial. So imagine how this would go. So now the doctor's on the witness stand. I now spring this on him. Before he has a chance to utter a word in response, guess what? His attorney jumps up, he objects, he screams, he yells. The judge throws the jury out of the courtroom, and now the judge starts yelling at me. "Counselor, you knew you had to turn this over. Why didn't you do it?" And now I better have a good explanation. Now I can't use that great piece of information. So now if I were to ask the doctor whether he ever said that he screwed up, if he turns around and says no, how can I say different? Well, my client will get up on the witness stand and say, "Oh, the doctor told me in private that he did." Great, so now you have a he said, she said scenario. Who's the jury to believe? They don't have that video to look at. They don't have that to bolster your case, to see it. The better practice is, when we learn of this, now we make a copy of it, send it off to the defense attorney. Now they can deal with it. Whether they try and ask the judge to keep it out, or whether they do something else, or coach the doctor, or prep the doctor, I shouldn't say coach, prep the doctor for the questions that are going to be asked. Or maybe simply sending off that copy of that video to the defense attorney might trigger them to realize there's no way they can go ahead and defend this case. So there are a lot of good reasons why this has to be turned over earlier rather than at the last minute. Why do I share this with you? I share this with you because this does come up from time to time, where we have a video or a document or a medical record that now somebody wants to spring on the doctor at the time of trial, and now he's going to be stuck. He's not going to have seen it before. Well, neither has the defense attorney, and that may land the attorney who's trying to introduce that evidence in hot water. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in the state of New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.